You're driving home from dinner. Red and blue lights flash behind you. You pull over. The officer walks up to your window, shines his flashlight inside, and says 5 words that change everything. I smell marijuana in here. Your heart pounds. You haven't smoked anything. Or maybe you have. Maybe it's legal in your state. Maybe it's not. What you say in the next 10 seconds will determine whether you drive home tonight or spend the night in jail. Most people panic. They start explaining. They start apologizing. They start giving the officer exactly what he needs to search their entire vehicle. But here's what 99% of drivers don't know. That phrase, "I smell marijuana," is one of the most powerful tools in an officer's arsenal. And in most states, your response doesn't have to help him use it. Every single day in America, thousands of drivers hear those exact words. And every single day, hundreds of them talk themselves into a search they could have legally declined. They think honesty will help them. They think explaining will make the officer go easy on them. They think they have nothing to hide, so why not cooperate? Here's the problem. The moment you start explaining, you're not being cooperative. You're being a witness against yourself. I've spent years analyzing traffic stop cases and studying how courts interpret the Fourth and Fifth Amendments during these exact encounters. And I can tell you this with certainty. There are specific phrases you can say that protect your rights, and specific phrases that destroy them. Today I'm going to show you exactly what happens when an officer says, "I smell marijuana." I'll break down when you must respond, when you should stay silent, and the one phrase that works in every single state, legal or not. Miss this, and a simple traffic stop becomes a full vehicle search. Know this, and you keep your constitutional protections intact. Now this is educational content, not legal advice. Every situation is different. But the principles I'm about to share come directly from Supreme Court rulings and state court decisions. Let's start with what the law actually says. Here's the legal reality that will surprise most people. In many states, the smell of marijuana alone is no longer enough for an officer to search your vehicle. This is a massive shift from even 5 years ago. The courts have recognized that with marijuana now legal in some form in the majority of states, the smell alone doesn't automatically indicate a crime. But here's where it gets complicated. This varies dramatically by state. In states like Colorado, Maryland, and Minnesota, courts have ruled that the odor of marijuana is not sufficient probable cause for a search because the smell doesn't distinguish between legal possession and illegal possession. The landmark case is People v. McKnight from Colorado, where the court explicitly said that the smell of marijuana is no longer indicative of criminal activity in a state where possession is legal. But in states like Texas and Florida, where marijuana remains fully illegal, the smell absolutely can establish probable cause. Officers in those states can use "I smell marijuana" as legal justification to search your entire vehicle without your consent. So the first thing you need to understand is this: your state determines your baseline rights. But here's what most people miss entirely. Even in states where the smell creates probable cause, how you respond still matters enormously. Because officers aren't just noting what they smell, they're building a case. They're documenting your statements. They're using your words to justify their actions. Every admission you make, every explanation you offer, every nervous apology you give becomes evidence. And that's true in all 50 states. Now let me show you exactly how this plays out when someone gets it wrong. You're pulled over in Texas for a broken taillight. The officer approaches and says, "License and registration, please." You hand them over. He looks at your documents, then leans in slightly and says, "I'm getting a strong smell of marijuana from your vehicle. Have you been smoking?" Here's what most people say. "No, officer. I swear, I haven't smoked anything. Maybe it's my friend, he was in here earlier. Or maybe it's the air freshener. I know it smells weird. I promise there's nothing in here. You can check if you want." You just made 3 catastrophic mistakes in under 10 seconds. First, you engaged with his accusation. You treated "I smell marijuana" as a question requiring an explanation. It's not. It's a statement designed to get you talking. Second, you mentioned your friend. You just gave the officer a new avenue of investigation. Now he's thinking about who else has been in this vehicle and what they might have left behind. Third, and this is the worst one, you said, "You can check if you want." That's consent. You just gave voluntary consent to search your vehicle. Even if the officer wasn't sure he had probable cause, even if his claim about the smell was questionable, you just eliminated any legal argument you might have had. The officer now searches your car. He finds a small amount of marijuana in the center console that you forgot was there, or that your friend left behind, or that doesn't even belong to you. You're arrested. You're charged with possession. And when your lawyer tries to challenge the search in court, the prosecutor plays the dash cam footage of you saying, "You can check if you want." Case closed. Your consent made the search legal regardless of whether the officer actually smelled anything, all because you felt the need to explain yourself. Now let me show you how this same stop should go. The officer approaches. License and registration, please. You hand them over. He leans in and says, I'm getting a strong smell of marijuana from your vehicle. Have you been smoking? Here's what you say. Officer, I'm not going to answer questions, but I'm not going to give you any trouble either. That's it. You're not denying, you're not confirming, you're not explaining, you're invoking your Fifth Amendment right to remain silent while simultaneously signaling that you're not going to be difficult. The officer pushes back. So you're not going to tell me if you've been smoking? You say, I don't answer questions, but I'll cooperate with your lawful orders. He tries again. If you got nothing to hide, why won't you just tell me? You stay calm, hands on the wheel. I'm exercising my right to remain silent. I don't consent to any searches. Now here's what happens next, and this is critical. The officer has a decision to make. In a state where the smell creates probable cause, he may search your vehicle anyway. That's his legal right. But you haven't given him anything additional. You haven't admitted to smoking. You haven't mentioned friends who might have left something. You haven't given consent. If he searches and finds something, your lawyer can challenge whether he actually smelled marijuana or whether he fabricated the claim. Your lawyer can argue about the reliability of smell as evidence. Your lawyer has options. But if he searches and finds nothing, you drive home. And if you're in a state where the smell alone isn't sufficient probable cause, your refusal to consent might mean he can't legally search at all. He might call a K-9 unit. But under Rodriguez versus United States, he cannot extend the stop beyond the time needed for the original purpose without reasonable suspicion of a crime beyond what he claims to smell. Your silence protects you. Your cooperation keeps you safe. And your explicit statement of I don't consent to any searches preserves your rights for court. But there's something else most people don't understand about this situation. The smell claim has different variations and each one requires a slightly different response. Let's break this down. First variation, the officer says, I smell burnt marijuana. In states where marijuana is legal, this is actually more significant than fresh smell because burnt marijuana suggests recent smoking, which could mean DUI. Your response stays the same, but you should be prepared for the officer to request a field sobriety test. If he asks you to step out of the vehicle, you must comply. Pennsylvania versus Mims established that officers can order drivers out of the vehicle for any reason. Don't resist that. But you still don't have to answer questions about whether you've been smoking. Second variation, the officer says, I smell fresh marijuana. In legal states, this is weaker because possession of fresh marijuana isn't a crime, but the officer might use it to fish for more information. Stick to your phrase. I don't answer questions, I don't consent to searches. Third variation, you're a passenger, not the driver. Here's what most passengers don't realize. Maryland versus Wilson says officers can order passengers out of the vehicle too, but passengers have the same Fifth Amendment rights as drivers. You don't have to answer questions. You don't have to consent to searches of your person. If the officer asks you directly, have you been smoking? You say, I don't answer questions. Now let's talk about state-specific responses. In Texas, Florida, and other states where marijuana is fully illegal, the smell likely gives the officer probable cause. Your refusal to consent won't stop the search, but it preserves your legal options. Say, I don't consent to searches, but I won't interfere with your duties. In Colorado, Ohio, and Maryland, recent court decisions have weakened the smell doctrine. Your refusal to consent carries more weight. The officer may not be able to search based on smell alone, but never assume. Always state, I don't consent to any searches. Let the court sort out whether the search was legal. In states with medical marijuana programs, if you're a legal patient, you might think telling the officer will help. It usually doesn't. Your medical card doesn't give you permission to smoke and drive. It doesn't explain away the smell. It just confirms that you possess marijuana. Stick to the script. I don't answer questions. I don't consent to searches. If he searches and finds your legal marijuana, your medical card becomes relevant in court, not on the roadside. Now there's one more scenario we need to cover, because this is where people really get themselves in trouble. What happens if you actually have been smoking? What if you're impaired right now? First, I am not going to help you evade a legitimate DUI investigation. Driving impaired endangers everyone on the road, including you. But here's what you need to understand about your rights, even in that situation. You still don't have to answer questions. Have you been smoking is a question. You don't have to answer it. You can say, I'm not going to answer questions. If the officer has reasonable suspicion that you are impaired, he can ask you to perform field sobriety tests. You can decline these in most states, though there may be consequences. If he arrests you and requests a chemical test at the station, refusing that triggers implied consent laws in most states, which means automatic license suspension. But on the roadside, during the initial encounter, your right to remain silent is absolute. You don't have to help the officer build a case against you. That's not obstruction. That's the Fifth Amendment. Now let me put this all together for you. When an officer says, "I smell marijuana," remember these key phrases. First, "I'm not going to answer questions." This invokes your Fifth Amendment right. Say it clearly and calmly. Second, "I don't consent to any searches." This invokes your Fourth Amendment right. Say it explicitly. Don't assume it's implied. Third, "I'll cooperate with your lawful orders." This keeps you safe. It signals you won't resist, but you're not waiving your rights. And fourth, if he searches anyway, "I'm not resisting, but I do not consent." This preserves your legal argument for court. Write these down. Put them in your glove box. Practice them until they feel natural. Because when those red and blue lights flash, your brain will go blank. Your heart will race. Your instinct will be to explain, to apologize, to cooperate your way out of the situation. But the roadside is not where you fight your case. The courtroom is. Your job on the roadside is to be polite, to be safe, and to say as little as legally possible. Keep your hands visible. Announce your movements before you make them. Don't reach for anything without telling the officer first. And remember, officers are doing their job. They're trained to investigate. They're trained to ask questions. They're trained to use the smell claim because it works. Your job is to protect yourself by knowing your rights and using them calmly. If this helped you understand how to handle one of the most common and most dangerous traffic stop situations, I'd appreciate a subscribe so more drivers can learn this. This was educational content, not legal advice for your specific situation. Always consult with a lawyer in your jurisdiction. Now I have a question for you. Do you know what to say if an officer asks to search your vehicle without claiming to smell anything? That question is actually more dangerous than the marijuana claim because most people give consent without even realizing it. I'll break that down in the next video. Remember, the smartest people aren't the ones who talk the most on the roadside. They're the ones who know exactly when to stop talking.